Good afternoon, ladies and gentlemen. I'd like to welcome you to the Business and Utility Subcommittee meeting. Today is Wednesday, February the 19th, 2025. It's 3 p.m. I'd like to call this meeting to order. Members, can you make sure you're logged into your device? And Madam Clerk, let's take the roll, please. Okay, take the vote.
Mr. Chairman, you have 9 members present. You have a quorum.
Thank you, Madam Clerk. Before we get started today, members, do we have any personal orders? If not, we do have a calendar today, so let's go ahead and get started. First up is item number 1. That's House Bill 1096 by Chairman Vaughn.
Thank you, Mr. Speaker. And
We have a motion. Do we have a second? We have a second.
Thank you for those.
Chairman Vaughn, looks like you do have an amendment.
I do, Mr. Chairman. Let me retrieve that for you. My amendment is coded 3718.
That's what I'm showing as well. Can we get a motion to second on the amendment? We have a motion. We have a second. Let's go ahead and put that on the bill. Members, we're voting to put drafting code 3718 on the bill. All in favor say aye. All opposed say no. The ayes have it. Chairman Vaughn, you are recognized on your bill as amended.
Thank you, Mr. Speaker. And what the amendment that we just put on did is it brought the effective date of this bill that we're contemplating being applicable to anything after July of this year, any new agreements. Here lately, in not only in our state and other states around, there have been this new type of collaborative effort between groups outside of organized government for community benefit agreements, or what they call them. And basically what that does is it third parties outside of people who are in receiving ECD grant money, third parties outside of local government. Sometimes local government is involved, but not necessarily the state government is not involved. And what they do is they come up and they put requirements on companies that are considering relocating into their area beyond what normal requirements due to zoning and land use are. And so what this bill does is this bill prohibits these local governments as well as NGOs and trade organizations from entering into or forcing people who receive ECD benefits from entering into that community benefits agreements. And so that's what this bill contemplates. We think it will result in it will take companies from feeling pressured who are taking ECD money from entering into these agreements. Now then, this is a permissive bill, so to speak, because if you do want to enter into those agreements, you don't have to take ECD benefit money. So that's, a few years back or last year, we passed a bill that said that if you are going to take ECD incentive money and you are going to be an organized labor employment base, that's okay as long as you have secret ballot elections. It's not a card check election. This takes this a little bit step further to where it says that If you are going to accept ECD grant money, then you will not be allowed to enter into a community benefits agreement. And we think that's a positive thing because that takes the pressure off the company from having to placate all these other folks that want to come in afterwards and put other extra requirements on them other than we do here at the state. So that's a long-winded explanation of what this bill is considering to do. I'm available for any questions.
Thank you, Chairman, for that explanation. Members, you've heard the explanation. Do we have any questions? First up is Leader Camper. You're recognized. The amendments on the bill. Yep. Yeah, you're recognized, Leader.
Thank you, Mr. Chairman. Chairman Vaughn, you know, when the Ford Corporation came to Blue Oval City, there was a group of us met with their foundation and took them around the area that they were coming into so that they can have appreciation of the people whose lives was about to get impacted based on them coming and the things that they were planning to do. And the company made some decisions to invest in those communities based on what they saw, what they believe is true, and how they wanted to, have a relationship with the community. Would this bill affect those types of activities, those kinds of things that the company has decided is something that they chosen to do?
Chairman Vaughn, you recognize.
Thank you. Thanks, Leader. In those instances, because Ford is, they operate, they have the Ford Foundation, they have a bunch of these other things. They didn't sign a they didn't sign a binding agreement with all of these groups. That's a situation to where they understand the value that their organization can bring to those communities, and they're voluntarily engaging in those activities. What we're trying to preempt here is to where a local municipality can tell, let's say that Clark Boyd, State Farm agent, is going to relocate, and he is such a tremendous provider of services and an employer of so many people in an area that he has applied for ECD benefits and has received them. Once he does that, then he is precluded from and is protected from the area, the local area that he's in. Suddenly a local government saying, oh, by the way, Mr. Boyd, you have to pay your employer's local wage. You have to use these vendors. You have to, as well as provide these amenities that are not contemplated in local zoning or land use rules. So it prevents additional requirements from being placed on a business moving into an area that surpass what any other business would be going into that area to do. But Ford is such a, and by the way, I don't think Chairman Boyd's recruit. He's not, I don't think he's looking to move. I don't think he's looking for any ECD grants, merely a hypothetical. But in that case, I don't think that Ford entered into those agreements, and plus they're such a, in that case, Ford could do what they want to do because Ford Foundation is where a lot of those those monies and investments are coming through. So in that case, I don't believe that this would apply.
Leader Camper, after such a thorough analogy, I would doubt you would have any questions, but if you do, you're welcome to follow up.
Thank you, Mr. Chairman. Okay, so whatever they may have decided on at this point, this bill wouldn't affect them. But another company coming, should they receive some ECD dollars, they could conceivably do something similar as long as it's not called a community benefit agreement. They can't sign any type of agreement, even if it's something they are desiring to do. Would this bill preclude them on their own deciding they want to have a relationship with whichever entity it is that they want to be able to give back to their community in whatever way they deem is necessary or possible or enhances? Would they be precluded from doing it, even if it's an initiative on their own part?
Chairman Vaughn.
As long, Thank you, Mr. Chairman. As long as it doesn't do any of the following, and I think in our marked calendar, it does a really great job of delineating this. It's other than this, it says, as used in this bill, a community benefits agreement means an agreement or understanding of any type between an employer and a community group, non-governmental entity, or other third party other than the state that does any of the following things. It contractually binds the employer to provide to fund or provide specific attributes, services, or amenities, mitigations, or anything of value to a community or non-governmental entity. It establishes employment criteria of any type or form, including wage and hour criteria, or it provides for and requires the employer to utilize a trade union or other unionized workforce where the employees collectively bargain with the employers for wages, hours, or working conditions. So those are the things that are prohibited to be in a community benefit agreement.
Leader Camper, you got anything else?
No, Mr. Chairman, thank you.
Chairman Clemens, you recognized.
Thank you, Mr. Chairman. And Chairman, I realize this isn't your legislation, and I don't know. I know you're signed on to it, but I will have to direct these questions to you. I guess my question is, you know, we spend a lot of time in this committee and in the Full Commerce Committee talking about removing regulations and not interfering with private businesses and private companies. And so the interesting thing about community benefits agreement is that they require 2 signatures. It's not something that's one-sided, and it's not something that's necessarily forced on any company. It's something that a company voluntarily enters into. I mean, I'm sitting here holding the CBA with the Nashville MLS Soccer Club. The soccer club signatures on here, other people's signatures are on here. And these CBAs, I don't know what our problem is with community benefit agreements. These community benefit agreements, while they do sometimes address minimum hourly wages and workforce development and OSHA compliance, they ask for community amenities and services for childcare. They provide opportunities for local artists to participate in beautification projects around a development. They have partnerships with school systems, after-school programs, donations of equipment, affordable housing efforts, volunteer hours per year, workforce development, adult internships, adult professional programming. I mean, the list goes on and on. The Titans, we gave the Titans $452.7 million in bonds over 20 years, and they voluntarily entered into a community benefits platform that has an inclusion program for wages. It has a small business support program, a Hope and Imagination Center, paid virtual internships and adult professional programs with developers like yourself, a Catalyst Fund to assist with affordable housing, Keep Nashville Home campaign for senior citizens to make them aware of housing security assistance programs. I mean, these are things that their partnership with TSU, Metro Public Schools, mental health initiatives. I mean, these are the things in community benefits agreements. And if private companies want to enter into these with the community for goodwill or whatever purpose, who are we as a legislature to say they can't do that? And then we're going to deprive them of the benefits that are available to other corporations and put them on create a different playing field for corporations that want to do these things and enter into these 2-sided agreements. I don't know where we as a body get off telling corporations and businesses what they can and cannot do, and then making state funding contingent upon that. So my question is, and again, I know this isn't your bill, but why are we telling private businesses what they can and cannot do, and why they should not do these wonderful things that are contained within CBAs?
Chairman Vaughn.
Well, I would offer this. Thank you, Mr. Chairman. I would offer this to my good friend from Davidson County. I think that what you're seeing, what this bill seeks to do is it seeks local communities from leveraging the approvals for a project into these additional requirements that are not required by other places. these third-party groups. If somebody wants to voluntarily set up, if I'm a business and I want to relocate somewhere and I want to participate, I want to partner with TSU for doing something, that's fine. I can do that. But I'm not going to sign an initial community. I'm not going to get into a negotiating process where a local government says your relocating here is contingent upon you doing all these things, and we'll let you know whenever it is, when you reach a bar high enough and a threshold high enough that we're going to allow you to come into our community. What we're saying is that land use, zoning laws control that. If you're going to relocate to an area that is an approved use for that area and you're receiving benefits from ECD, that's enough. That's enough for you to relocate there. You don't get given someone else the opportunity to load the wagon on you at that point in time with other ancillary requirements and requests.
Chairman Lafferty, you recognized.
Thank you, Mr. Chairman. I was just curious, with the third-party administrators handing out, for all practical purposes, the taxpayers' money for these projects, is there any way, if, say I'm a company and I want to apply for one of these benefits, and then you're the third-party administrator, and you have this list of items that I must comply with in order to get that money, and I go, wait a minute, that's a bridge too far. Is there a reporting mechanism that I can reach back to the state and say, hey, these third-party administrators are putting these undue burdens. We're fully capable of doing the job, but because we don't want to participate, we've now been cut out of the program.
Chairman Vaughn.
What this does two things, and I think one of the real positives from it is this law seeks to protect those companies that are relocating. Their answer to these folks that are putting this pressure on them is, you can't compel me to break state law. So that solves the issue at that point in time, or I would consider it to be that to do the case.
Chairman Lafferty.
No, thank you. I appreciate that. Thank you, Chairman.
Representative Hardaway, you recognized.
Thank you, Chairman. Of course, I have to go ahead and preclude my questions with, I know it's not your bill, sir, and it's nothing personal in my questions. But I'm having trouble understanding how this is even constitutional, that we're getting into a contractual relationship that's not really any of our businesses, either as legislators nor unless it's something in ECD's contract. Why would it be our business of what two entities who have a meeting of the minds agree to? Why are we in that contractual relationship when either one can say, we don't want to be a part of this, so we're just not going to do business? That's the part I'm having trouble with.
Chairman Vaughn.
I understand that, but I also understand, to my good friend from Shelby County, that what we're doing is we're precluding someone from exerting leverage over a company that's wanting to enter into an area, and they have ways to affect that, such as maybe withhold building permits or whatever, until you introduce. They're adding continuous layers onto, hey, you're going to do this, you're going to pay your people this, then you're also going to donate this to us, and you're going to do this to us. Well, that's a moving target. And what we're doing is saying that, hey, there's not going to be a moving target. You do this, and then you can do this. And by the way, if you would prefer to do a community benefits agreement, if that's in your corporate culture and that's something that you want to do, you're free to do that. You just won't get a check from the state of Tennessee and Economic and Community Development Agency. So that's it in a nutshell. That there's decisions to be made. And so what we're doing is we're seeking to streamline the process by not having it cluttered if someone is seeking these benefits and it's a project that's deemed worthy by ECD to qualify for whether it's be fast track infrastructure improvements or employee training dollars, then you don't, if it's, once that happens, then it protects these people from getting leverage from local communities from, like I said, adding additional aspects to the approval process to them that's going to continue to add up cost to them. If later on down the line, as long as they don't have to enter into a binding agreement, if they want to voluntarily participate and, if they want to do something that benefits their business with a local community afterwards, that's not considered within this. But what this precludes is a or a contractually binding agreement on the front end.
Representative Hardaway.
Thank you for that, Mr. Chairman. But isn't the whole reason that we have cities and other places that have villages and hamlets, isn't that because you have a group of folks who come together based upon their principles and their values and other considerations to say, this is how we want to live. This is the environment we want to expose our children to and what we want to walk out of our house and be exposed to every day. I'm just not seeing how we're not infringing upon what should be just basic rights, possibly basic constitutional rights, but basic human rights to want to live where you can tell folks what kind of environment you want to live in. And I'm curious, is there any, and this might not be a question for you, Chairman, but we might have to go out of session. Is there or are there any constitutional issues with this?
Representative Hardaway, are you directing that to Chairman Vaughn, or are you wanting to go out of session? I heard you mention that. Are you wanting to hear from legal services on that?
Let's hear from legal. I like Chairman Vaughn.
Okay, members, we're going out of session. And we will represent our legislative attorney. Go ahead, state your name for the record, Levin.
Levin Middleton, Office of Legal Services. In terms of imposing on obligations of contracts, the general rule is that we can't pass laws that retroactively do that for contracts that are already in place, particularly with the amendment on this bill that specifies that it applies to contracts and agreements and understandings entered into, executed, or modified after the effective date. I'm not aware of any constitutional issues.
Representative Hardaway.
And thank you for that, Counselor, and thank you, Chairman. I've got some more questions for Chairman Vaughn, but I'm going to ask him off the record.
Okay. Thank you, Levin. Appreciate it. Anybody else for legal services? If not, members are going back into session. And Representative Hardaway, we'll go back to you with your questions for Chairman Vaughn.
I'm clear, sir.
Okay. Chairman Clemens, you recognize.
Thank you, Mr. Chairman. I didn't get to really finish up a moment ago. So my point is these community benefits agreements are entered into between two parties. It's not one-sided, it's two parties. And generally with public policy, we seek to, pass laws to protect the community, protect the public from bad actors. And that's generally the limited manner in which we want to regulate private businesses. And generally this committee seeks to limit our regulations on private businesses. And so what we have here, community benefits agreements only benefit the community. They only generate goodwill. And so here we are seeking to pass public policy that not only tells private business what they can and cannot do, and using state resources as the hammer, or the carrot rather, but disincentivizing them from doing beneficial work in the community and generating goodwill and assisting the community in which they're going to do business. So I just think this is contrary to all notions of good public policy. on multiple levels and generally against the grain with what we generally do on this committee. So again, I recognize this is your piece of legislation, but I don't know why we would want to disincentivize companies from entering into these two-sided agreements that do nothing but benefit the community. Thank you, Mr. Chairman.
Representative Bricken, you are recognized.
Question on the bill.
Question's been called. Without objection, members, we are voting to send House Bill 1096 as amended to full commerce. All in favor, vote aye. All opposed, vote no. Has every member voted? Would any member like to change their vote? Okay, well, whenever you're ready, Representative Hardaway. Madam Clerk, take the roll. Or Madam Clerk, take the vote. I'm sorry. I'm still new at this.
Mr. Chairman, you have 8 ayes, 2 nays, 0 present not voting.
Thank you, Madam Clerk. Without House Bill 1096 passes and goes to full commerce. Next up, we have House Bill 683 by Leader Lamberth. We have a motion. We have a second. Leader Lamberth, you're recognized on your bill.
Thank you, Mr. Chairman. This doesn't have anything to do with community benefit agreements, but it will benefit the community Scouts Honor. So this is a heavy topic. This came to me from a security expert that identified a failing in the Tennessee state law. We have armed guards, but we have armed guards that many times are protecting schools or churches or sensitive areas, and there's no upper level armed guard. There's not an enhanced armed guard license, and that's exactly what this creates. That way, if someone wishes to hire, an armed guard to protect their property for whatever reason, they'll know that there is an upper level that probably they'll wind up paying more for, but at least they'll know that it is that upper level armed guard, not just kind of the standard base. That's what the bill does, Mr. Chairman.
Thank you, Mayor. Thank you, sponsor. Members, you've heard the explanation. Do we have any questions for the sponsor? And questions been called. Members, we're voting to send House Bill 683 to full commerce. All in favor, vote aye. All opposed, vote no. Has every member voted? Does any member need to change the vote? If not, Madam Clerk, take the roll or take the vote. Good Lord.
Mr. Chairman, you have 10 ayes, 1 nay, 0 present not voting.
Congratulations, Leader Lamberth. House Bill 683 is on its way to full commerce. Next up, members, we have House Bill 459 by Representative Martin. We have a motion. We have a second. Sponsor, you recognized on your bill.
Thank you, Mr. Chairman and committee. House Bill 459 helps the Tennessee Secretary of State stop foreign adversaries from using Tennessee's business filing system to advance their dangerous agenda. I'll give you an example. In 2023, the FBI and the Department of Justice found that North Korea had created a registered 3 businesses in Wyoming to mask an attempt to raise funds for its weapons of mass destruction program. The Department of Justice said that North Korea used these 3 companies to send thousands of skilled tech workers to nations like Russia and China. The legitimacy of the U.S.-based company deceived various companies here and internationally into hiring these workers as freelance IT workers. And the revenue from the business promoted North Korea's weapons of mass destruction program. The FBI notified the Wyoming Secretary of State, who was able to dissolve these 3 entities after finding evidence of fraud. However, the Wyoming legislature has since brought legislation to remove business owned or controlled by a foreign adversary as designated by the U.S. Secretary of Commerce, even if no technical fraud was found in the filing. House Bill 459 grants the Tennessee Secretary of State the limited authority to dissolve a business owned or controlled by a foreign adversary as defined by the Federal Secretary of Commerce. And this bill also standardizes this language for the Secretary of State to dissolve these entities all across all business types. The Secretary of State's team is here, and I stand for questions that you would have and would appreciate a positive recommendation.
Thank you, Representative Martin. Members, you've heard the explanation. Representative Bricken, you're recognized.
Thank you, Mr. Chairman. Certainly, Representative Martin, I support your bill here. Just have a question dealing with, from the Secretary of State's office. I don't know how they do a deep dive behind the names of the filing people to learn that they are foreignly controlled or not. If you talk to the office and as far as operationally, how this is accomplished or not?
Sponsor, you recognize.
Yes. This was brought to the attention by the Justice Department and by the FBI to the Secretary of State in Wyoming, and that is how things like this that's how that was discovered. And so I think that this is going to allow our Secretary of State to be able to act in a more prudent manner when those things are brought to our attention.
Representative Birkin.
Thank you. Is this on a prospective basis, or will they go back through all current recordings and look at the ownership of existing corporations in Tennessee?
Sponsor.
Mr. Chairman, I would defer. I know that we have on the witness people from the Secretary of State's office. I think that's an excellent question, and I would prefer to get the attorney with Secretary of State's office, if that would be okay, if we could go out of session for that.
Absolutely, sponsor. Members, we are going out of session, and I'd like to bring up Mr. Michael Harmon from the Secretary of State's office. Just be sure to state your name for the record and make sure your microphone is turned on, Michael. You're recognized.
Michael Harmon, General Counsel for the Secretary of State's office. The intent of this bill is to give the Secretary of State tools if we're faced with a situation like Wyoming was faced with, where the Department of Justice, the FBI, or a credible authority brings to us evidence that there's been misuse of our filing system. This is more of a shield. It's not a sword. We're not going through every filing that we have to try to ferret out whether a specific entity is owned or controlled by foreign adversaries. We think it'll be limited. We hope that it's never needing to be used, and the fact that we have the tools will be a sufficient deterrent.
Representative Birkin, do you have anything? Okay, members, while we're out of session, Representative Hardaway, you recognize.
Thank you, Chairman, and thank you for being here, sir. So the initiation would have to be by the federal government, those two agencies that you cited?
You recognized, Michael.
No. Practically, we anticipate it would be by somebody at the federal government, but we would have authority. For example, if we found information through a media, if 60 Minutes ran something on a Tennessee company, we could look into it that way. The point here, Representative Hardaway, is not that we are going out proactively looking for them through our whole filing system. We're using this as a tool that if it's found, if this is discovered, we have the tools in place to prevent the misuse of our filing system. And it's just for, again, foreign adversaries that are defined by the Department of Commerce.
Representative Hardaway.
Thank you. Would there be any subsequent follow-up by the AG for criminal or civil prosecution if we found that there were false filings?
Mr. Harmon.
We would anticipate, yes. If there was a filing that fit under here, we would absolutely be working with the Tennessee Attorney General's office. The action that we would be able to take here is to administratively dissolve the entity, which means they can no longer do business, but we may need an enforcement mechanism, which would be the Attorney General's office to take action if there was any needed here.
Representative Hardaway.
Thank you, Chairman. That's all I had.
Chairman Clemens, sorry.
I'll take it.
Yes, I will.
Give me that gavel, Bone. Thank you for being here. I appreciate it. And I like your hypothetical about 60 Minutes. I understand. My question is this. So what is the verification process? And Representative Bricken hit the nail on the head with my concerns, and Representative Hardaway. Well, if the Secretary of State is the one who discovers they're controlled by or operated by one of these foreign governments, what is his verification process? And does the Secretary of State's office have the necessary tools to do that? Or then wouldn't he run it through the federal government to verify that? Because I could see him administratively dissolving something and creating liability for the state of Tennessee. So what's that verification process look like?
Mr. Harmon, you recognize?
Practically, we would be working with other authorities, whether that's in Tennessee or at the federal government. It would almost certainly be at the federal government, given this type of situation that we're looking at. I'll also note that, to follow up, if I may, there is an appeal process here if someone is administratively dissolved. There's actually two levels. One is internally with the Secretary of State's office. They can show through a subsequent filing that the issue has been corrected, and then there is a right of appeal to the Davidson County Chancery Court as well.
Chairman Clemens?
And so what happens if they are designated as such by the federal government after they've been doing business in the state of Tennessee? And so at that point, we're just going to administratively dissolve them once they go on that list. And then I guess they have the opportunity to appeal.
Mr. Harmon?
It would be an entity that is owned or controlled by a foreign adversary. So it must be the government itself. There's no specific list of companies that these are put on. The list is the foreign adversary list, which there's currently 5 countries plus one, the Venezuelan government run by a specific individual. Did that
Chairman-
answer your question?
Chairman Clemens?
Yeah, thank you. I appreciate that. And just for clarification, because I know a lot of these foreign governments are setting up, through various channels, through separate degrees of LLCs or whatever, and buying up a lot of real estate across this country in certain cities. And so to the extent they are doing that, this would give the Secretary of State the opportunity, regardless of whether or not they falsely executed a document, just because it's controlled by that foreign government, the right to administratively dissolve that entity.
Mr. Harmon?
I believe the answer is yes. This would give the Secretary of State the limited authority to administratively dissolve an entity owned or controlled by a foreign adversary, China, Russia, Cuba.
Chairman Clemens?
Sorry, Mr. Chairman. And does that include their leader or just the government itself? Like, so if a leader of a foreign country, one of these foreign countries, was hiding money or wanting to place money into the U.S. or into the state of Tennessee through various LLCs, does this also include them, even though they're not the government themselves? Would they be considered a state actor, so to speak?
Mr. Harmon?
If the entity is controlled by the government, by the foreign adversary, which is a government. So this is a limited authority. If there was a leader that in her or his personal capacity was doing something, yet the entity was not owned or controlled by the foreign adversary itself, this bill would not grant the power to dissolve that entity. This is a very limited power.
Okay.
Thank you.
Chairman Clemens. Leader Camper, I've got you up next.
Okay, thank you, Mr. Chair. Yeah, thank you, Mr. Chairman. There's also a provision in the bill that deals with materially false information. Is that separate and apart from this foreign adversary, or it's just a person who may have signed it? Maybe it says knowingly, but is this only with respect to the foreign government, or is this just in general?
Mr. Harmon?
General. These are powers that are currently granted to the Secretary of State already, with one limited exception. And this is standardizing the language across different business types. We looked at this issue when we were looking at what happened in Wyoming and saw that it would have been good, I think it is good, to standardize the language across different business types, LLCs, corporations, limited partnerships.
Thank you, Mr. Chairman. Thank you for your answer.
Members, while we're out of session, we have Mr. Harmon here. Is there anybody else that has a question? If not, members are going back in session. We're back on the bill. Representative Martin, or members, do you have any questions for the sponsor? Representative Burke, you recognized.
On the bill.
Question's been called without objection. Members, we are voting on House Bill 459 to send it to full commerce. Please cast your vote. Has every member voted? Does any member wish to change their vote? If not, Madam Clerk, take the vote.
Mr. Chairman, you have 10 ayes, 0 nays, 0 present not voting.
House Bill 459 passes and is on its way to full commerce. Members, that brings us up to item number 4. Representative McCalman, did he roll that bill? Okay. And let's move to item number 5. That's House Bill 862 by Representative Parkinson. We have a motion. We have a second. Representative Parkinson, you are recognized.
Thank you, Mr. Chairman and committee. I serve on the TASER board, and this bill simply directs TASER to study the economic impact of the cosmetology and barbering industry in our state within the funds that they already have. So it won't cost TASER any more money than what they already have. And then to report it back to this committee, actually.
You've heard the explanation. Does anybody have a question for the sponsor? Representative Bricken, you are recognized.
Thank you, Mr. Chairman. This is not directly on the bill, but maybe the chairman can clarify. TASER studies, is it the number of TASER studies that are authorized by the General Assembly actually fixed, or can it be expanded each year?
Stand by for just a minute on that, Representative Bricken. Representative Bricken, I'm not sure how many TASER studies get funded each year. We don't determine whether it gets funded or not, just whether or not it's worthy of it. So the vote here does not guarantee that one happens, but it'll move it in that direction.
Thank you.
Chairman Vaughn, you recognized.
Thank you, Mr. Chairman, and to my good friend from Shelby County. First off, let me say that your dedication to this profession is admirable, because if I don't feel like I've been to committee unless I've contemplated a cosmetology bill brought by Representative Parkinson, and I have actually learned a great deal about that industry. Shout out to my mother-in-law. She fixes hair too. So,
Right.
But anyway, my question for you is for what purpose, this is a fine, I don't have a problem with your bill or your request of TASER, especially with you serving on TASER. But I'm just curious as to what are you going to do with the information once you get it?
Sure.
Representative Parkinson, you recognize.
And thank you, Mr. Chair, and thank you, Chairman, for that question. The cosmetology industry is a $1 billion plus entity, and we've yet to quantify what that means to us in the state of Tennessee. Once we get this information, I want to see how we can utilize that information and possibly create more incentives to build more on that business, or that industry rather, in our state. I would like for us to be the world capital or the world center for the cosmetology and barbering industry. That's the goal.
Chairman Vaughn, anything else?
Well, that's cool by me. I find that, for some of us, that industry is a little bit discriminatory, but, we do. I'm just saying, I'm supporting an industry that hadn't got much to work with up here. But anyway, I appreciate you bringing the bill, and I'm going to support it.
Sponsor, you recognized.
Thank you again, Mr. Chair. And I do want to thank all of you and the body, for your indulgence on, me pestering you with cosmetology and barbering bills. But while I'm not a cosmetologist or a barber, I'm not in the business in no form or fashion. We've benefited a lot of people through the legislation that we've passed, especially when you think about what we've done with natural hair, what we've done with the apprenticeship portions of these bills, what we're doing, with these schools and helping those people that want to be in this industry. And we've literally increased the number quite a bit of those individuals that are licensed professionals in our state. The other thing is about the cosmetology and barbering industry is this: when they come out of the schools and become licensed individuals, they also become business owners. So this is a business that breeds businesses also.
Chairman Vaughn, you recognize.
Yeah, I appreciate you mentioning that because I think that I'd like to think I'm the most important person in my wife's life, but I know that her hairdresser is a close second. Our schedule is built around what days she's getting her hair done, particularly if there's any color involved. But hey, look, I support a business. And shout out to Halo Salon in Rossville. Those ladies,
There you go. Fix
they
it.
do a great job.
That's good
And every
recovery.
time I spend there, I get a great return on. So
That's a
thank you to the
great
ladies
recovery.
at Halo Salon. But the point that you just made is very valid. Is the fact that whenever I see how successful some of these folks can be, we're quick to turn a blind eye to trades that we don't normally contemplate. And these people are fantastic business operators and are very, very successful.
Yes.
And it's a trade that it's woven into the fabric of all of our lives.
Yes.
And so I like where you're going with it, and I appreciate it.
Thank you, sir.
Leader Cochran, you are recognized.
Thank you, Mr. Chairman. Representative, just one quick question, kind of similar to Chairman Vaughn's. He asked you maybe what you hope to do with the information, but do you have something in mind that you're hoping to discover? I mean, is there an idea that you have that you're hoping maybe that this task or study would reveal?
Sponsor, you recognize.
Thank you, Mr. Chair. Yes, what our state is generating in this industry, right? I think a lot of times we miss an opportunity to get that quantitative data, for these industries. You look at, even at our TCATs, there are usually waiting lists for students coming out of high school to get into those programs in our TCATs. And so that tells us that there's an incredible demand, for this business. And apparently it's a recession-proof business. People are still going to get their hair done, still going to get those haircuts, even during the worst of times. And so I just want us to take this opportunity, quantify it. Let's see how much money we're generating in the state, and then see also if we can get those conferences to our state, see if we can get, more investment in that industry into our state. And especially when, some of you may not realize, but even in the selling of hair, it's $1 billion plus industry. Lashes is $1 billion plus industry. And we have changed laws so that we made it easier for people to become licensed in our state and, become lashing techs. But these are $1 billion industries that are right under our nose. And we just hadn't taken the opportunity to quantify it.
Representative Bricken, you're recognized.
Thank you, Mr. Chairman. I was going to call the question, but I came up with a question. If you don't get funding for your task or study, the University of Tennessee Economic Research Department would be a great place to go and ask them to provide this study. So. You call the question.
Just a quick response, Mr. Chair.
Sponsor, you're recognized.
Thank you. And Chairman Bricken, thank you for that. And TASER is one of the best bodies that we have here at the state of Tennessee. They're incredibly thorough. And so I know with them hearing you say that, they'll probably tap in anyway. Lastly, this bill is drafted so that it is funded within the existing funds that TASER already has.
Representative Barrett, you recognize.
Thank you, Mr. Chairman. Move previous question.
Question's been called without objection. Members, we're voting to send House Bill 862 to full commerce. Madam Clerk, can you open the board? Members, all in favor vote aye, all opposed vote no. Have all members voted? Would any member like to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays, 1 present not voting.
House Bill 862 passes. It's on its way to full commerce. All right, let's see. Next up is item number 6, House Bill 499 by Representative Jones. Representative, do we have a motion? Do we have a second? We have a motion. We have a second. Representative Jones, you are recognized on your bill.
Thank you, Chairman. This legislation is a technical cleanup bill from the Secretary of State's office to clarify the form of notice that a registered agent provides a business when the registered agent resigns. A registered agent is a person or company designated to receive important legal documents on a company's behalf, and every business registered with the Secretary of State's office must have a registered agent on file with the office. If the registered agent resigns, then the business must appoint a new agent and tell the Secretary of State's office who the new agent is. To ensure that the business knows that it needs to get a new registered agent, the business receives 2 notices from the Secretary of State's office. The first from the registered agent before the agent resigns, and the second from the Secretary of State's office after the registered agent resigns. There's been confusion, as you can imagine, on the format of the first notice, that is the notice that a registered agent provides to a business before resigning. This bill simplifies the statutory language concerning this notice to require that the registered agent simply provide a written notice of its resignation before the registered agent submits anything to the Secretary of State's office. This statutory change will not change the fact that the business receives 2 notices. It just clarifies and simplifies one of the notices. With that, I stand ready for any questions.
Sponsor, we appreciate that explanation. Chairman Vaughn, you are recognized.
Thank you, Mr. Chairman, and to our newest colleague from Knox County, I believe.
Sponsor, you recognized.
Unicoi County.
Unicoi. Okay. Excuse me.
Chairman Vaughn.
Thank you, Mr. Chairman. All right, so this bill and by the way, this complex legislation for your first bill, hey, good luck with this. This is really changing the way that we see business here in the state. You mentioned a registered agent. And if they resign, and I guess if they die and they contemplate a change, what if the registered agent is just lousy at their job? What happens then?
Sponsor, you recognize.
They stay the registered agent until the company decides that they're not anymore.
Chairman Vaughn.
Thank you. So it's really, in your opinion, as our Secretary of State is out fighting foreign adversaries, he's here in the state for registered agents who may or may not be derelict with their duties. This bill does not address anything like that. Does he have any additional powers, sponsor, to deal with that?
This bill, this is just a technical change on this one issue with the resignations. As far as we do have the Secretary of State's office here if you want to talk about the other ways that they can.
Chairman Vaughn.
Thank you, Mr. Chairman. I'm going to have to think about this for a while and see. This is some weighty changes we're being asked to contemplate. I'm going to have to sit on this one for a while and think about it, but I'll yield to some wiser members of our committee to dig further into this issue.
Representative Barrett.
Thank you, Mr. Chairman. And Chairman Vaughn brought something up there, I think inadvertently, that I don't think any of us have contemplated. So Madam Sponsor, what if the registered agent is a foreign adversary?
Sponsor.
Would you like to go out of session and let them address that?
No.
I don't think that's necessary. Chairman Clemens, did I see your hand?
We all know that you can't have a registered agent out of the state, right? Representative? I just want to make a note of this. Those 2 individuals are in your own party. They did that to you, not us friendly folks up front. And I think confusing Knox County and Unicoi County are fighting words in certain parts of the state. So thank you for this great legislation. I have some questions for the Secretary of State, but I'll ask them in my office. Thank you, Mr. Chairman.
Members, do we have any other questions? Did I see Representative Hardaway's hand? You recognize, Representative?
Thank you, Mr. Chairman. I'm going to try to set an example for the rest of my colleagues. I'm calling the question if there are no other questions for the sponsor. I don't see any hands, so I'm going to call the question for the freshman.
Members, I don't think you can talk and call the question, but there are no other questions, Representative Hardaway. So we agree with the spirit of what you're trying to do here. So Representative Jones, congratulations on your first bill before the subcommittee. You presented very well. Members, we are voting on House Bill 499 to send it to full commerce. Madam Clerk, can you open the board, please? Members, we are voting to send it to full commerce. All in favor, vote aye. Opposed, no. Has every member voted? Does any member wish to change their vote? How did we? That is interesting. Yeah, we need to fix that. Real quick, can one of y'all log out? But would both of y'all log out and log back in real quick? I would like to get this straight before we do the vote.
Oh, goodness.
I got to help the old folks.
Okay.
Okay, so members, what I'm being told by LIS is that your votes are being recorded, Leader Camper and Representative Hardaway. It's just a problem with the board. So are y'all both logged in right now? Okay, let's go ahead. Representative Hardaway, are you in? Yes, sir. Okay, Madam Clerk, take the vote.
Mr. Chairman, you have 10 ayes, 0 nays, 0 present not voting.
Congratulations, sponsor. House Bill 499, it passes and it's on its way to full commerce. Item number 7, House Bill 561, Representative Capley I'm going to roll him to the heel of the calendar. And I do need to go back to item number 4, House Bill 378. We're going to roll that 1 week. And then I'm going to hand off the gavel to Chairman Vaughn. I've got a couple of bills.
All right. Thank you. Next on our calendar for today is House Bill 1138 by Chairman Boyd. All righty. We've got a motion and a second. You're in the proper posture there, Chairman Boyd. Share with us what we're doing here.
Thank you, Mr. Chairman. Members, this is a pretty simple bill. It's brought to me by a constituent. We had a situation where there was some blasting going on in a neighborhood, and they were blasting pretty close to the home. And the member, the constituent had several things they'd like to do, but what we ended up thinking the easiest thing to do that would get them some resolution is to allow them to have access to a pre-blast survey at no cost. Now, currently statute allows that they have access to that. It's available to them. But in this situation, they were trying to charge them $150 for the blast report. And so we felt like it might be a good order if we could get that down and allow them to get it at no cost. And that's all the bill does, Mr. Chairman.
Thank you, sir. When I first read it, I was thinking, wow, where's the amendment? It looks like a caption bill, but it is actually the bill. All right. Anybody have any questions for Chairman Boyd on this fine bill? Excuse me, Representative Hardaway, you're recognized.
Thank you, Chairman. Just as there a definition already in statute for a pre-blast survey, or is that part of the bill?
I believe that's already an industry term, but I believe it is already in statute. So we know what it is that they're asking for.
All right, thank you.
All right, any other questions? Seeing none. Let's vote on House Bill 1138. All those in favor, please wait, I'm sorry. Boy, old habits die young, die hard. Let's record our vote, or Madam Clerk, would you take the vote, please? If all votes been cast, anybody want to change their vote? All righty, well, let's then, Madam Clerk, please read the results of the vote.
Mr. Chairman, you have 10 ayes, 0 nays, 0 present not voting.
Thank you so much. Chairman, your House Bill 1138 will be off on to full commerce. Next up, 1136, House Bill 1136 by Chairman Boyd. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman. Thank you, Mr. Chairman.
We got a motion and a second.
I do have an amendment, Mr. Chairman, drafting code 3552.
All righty. Thank you, sir. Please share with us. You want to get that in order, or do we need to talk about that before we? Let's go ahead and get that on there if there's no issues with anybody. Here, motion second on the agenda. Any questions? All those in favor, please signify by saying aye. Any opposed? No. Bill's amended. Now then, let's take up the amended bill. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman. And members, as y'all know, the last few years, we have really delved into the broadband business here in Tennessee, and we've got $800 and something million that are coming down from the federal government through BEAD that's going to help deploy broadband all across the state of Tennessee. But very recently at the federal level, broadband was changed from an information service, Title I, over to Title II, which is a telecommunication service. And there's really nothing we can do about that at the federal level. That's up to the FCC. But it does have implications at the state level because TPUC actually does have regulatory authority over telecommunication in the state of Tennessee, and they've not regulated internet pretty much ever since it's been out. So if it stays under telecommunications, it could create a little bit of a issue for us in Tennessee because it would put all internet under TPUC. We have spoke to TPUC. They don't want the authority over it, and we think it's better regulated at the national level under the FCC. So this would just simply clarify that it's regulated at the FCC and that it's not to be regulated by TPUC. That's simply what the bill does, Mr. Chairman.
Thank you so much for that easy to understand explanation. Chairman Clemens, you're recognized for a question on the sponsor.
Thank you, Mr. Chairman. And my question is, we passed a broadband bill several years ago that kind of shut the door on broadband being considered a public utility in the state and limited it to the companies that were already putting it out there, the private entities, and then electric co-ops in certain areas. And we prevented any other municipalities or local governments from being able to do it. Then we're already doing it. So, I mean, I really believe that broadband is a public utility in a lot of ways. And this seems to be slamming the door on that opportunity. Does this have any impact beyond what is already in the law on municipalities that may be providing these services already?
Thanks, sir. Chairman Boyd, you're recognized for response.
Thank you, Mr. Chairman. And you bring up a good point, Representative Clemens. The word public utility, or the term public utility, is a term that's used loosely, and oftentimes private utilities are considered public utilities when it comes to TPUC and regulation. But they actually, it's literally the telecommunication. Like back in the old days when people had copper telephone lines, they were regulated by TPUC. And as we've switched to most phone services being voice over IP through cable and then later through fiber, they've not had any regulatory authority over it, nor do they want it. And so if your question is it like a public utility? Maybe, but in statute, they don't have any authority over it now except telecommunication. And so just thinking ahead, if this stays under Title II and is considered at the federal level to be telecommunication, it could cast doubt on that, and it could create a situation where TPUC might think that they should regulate it, although right now they don't want to. And if they did, I don't think they have the capacity or the staff to even do it, nor do they want to do it, nor do we want them to do it. That would be sort of problematic to do that at the state level when it's already regulated so thoroughly at the federal level through the FCC. And would it limit your question, I think was specifically how did it affect municipalities? I mean, you know, there are some municipal governments, usually local power companies that are municipal in nature that do provide broadband. They could continue to provide broadband, but it shouldn't have any impact on that. I don't think. This is really a matter of who regulates them, the FCC or the Tennessee Public Utility Commission.
Chairman Clemens.
Thank you for that. And that's really my question as to whether or not we're somehow trimming their ability to continue providing those services. I know we boxed them in with legislation several years ago, and you know the statutory definition of public utility includes everything from telegraph to you name it, going back in time, and broadband certainly is very similar to that in modern times. So I don't want to trim the ability of these locals who are already providing this even more than we already have. So that's my concern. And then also, I had a question about the, I think in the amendment at section 3, it was section 4 in the original one with regards to 655109Q that required the report to the General Assembly describing the competitive nature of communications market in Tennessee. And it's been represented to me that that was voluntary and that the Utility Commission didn't want, or TPUC didn't want to do that anymore. Is that accurate? And I like knowing the competitive nature of the communications market in Tennessee. I think it's beneficial to us, but if there's a reason not to do that anymore, I just want to hear the explanation.
Chairman Boyd.
Thank you, Mr. Chairman. Yeah, that was put into statute years ago, probably at the tail end of when internet was provided through dial-up, through telephone services. And so it was still in there. They were putting a report together, although it probably wasn't a very complete report, and they were trying to provide it. But as we've seen the last few years, most anything internet related has been done through ECD. And so ECD has that coverage map that they put together that's pretty thorough. It kind of matches up with what the federal government is coming up with as well. And so most of our data regarding internet is coming from ECD now. And that report was not whole. You're asking them to report something that they don't really regulate anymore. And so they needed to get rid of that. They wanted to get rid of it. And the report really wasn't that valuable anymore, I don't think.
You good, Chairman Clemens? All right, thank you. Any other questions for the sponsor? Seeing none, we'll take a vote on this. Madam Clerk, could you take a vote, please? Anybody want to change their vote? Do so now. If not, we're going to close the vote. Madam Clerk, would you please read the results?
Mr. Chairman, you have 10 ayes, 0 nays, 0 present not voting.
Thank you so much. I'm going to hand the gavel back to our leader.
Thank you, Chairman Vaughn and members. Item number 7, House Bill 561 by Representative Capley is rolled 1 week. And members, appreciate y'all bearing with us as we figured out how to navigate these voting machines and how we call for the vote and everything. We'll get smoother as we go along. But we do have a presentation today. So members, we're going to go out of session. And I'm going to invite up Ryan King with the TECA. And I'm also going to invite up Chris Jones, who's the CEO of Middle Tennessee Electric, and Mike Parton, the CEO of Sequatchie Valley Electrical Co-op. And members, just make sure that the little red light is on before you talk down there, and state your name for the record. And we'll start with you, Mr. King. You were recognized as soon as your light comes on.
All right. Thank you, committee. Thank you, Mr. Chairman, Ryan King, Tennessee Electric Cooperative Association. And Chairman, thanks for the opportunity. You always like to have electric co-ops back every couple of years to educate new committee members and even committee members who have been around. Several of you know as much about electric cooperatives as many of us in the room today. So thanks for the opportunity. Thanks for the invite. As you guys know, we represent the electric cooperatives across the state. That's about 72% of our land mass in Tennessee that are covered by electric co-ops. That's 24. The number is 24 that we represent, many of which are in the room behind me. They're the fabric of your communities, many rural communities. You know the folks by when you see them at church, your kids go to the same schools, the staff members, the board members, et cetera. So we really like to emphasize and re-emphasize that our leadership are members of the community and the fabric of the community. Mr. Chairman, I'll speak with brevity. I know you've had a lengthy calendar, successful calendar here today, so I'll move quickly and let you hear from the other two gentlemen here beside me. But a little bit of background on electric cooperatives. We were created in the 20s and 30s, originally to overcome a population density issue. In urban areas, electricity wasn't a problem, but in rural areas, investors had no interest in investing just because it was a function of low population density and the returns weren't there. So through the foresight of state government, federal government, electric cooperatives were empowered private citizens to create electric co-ops, and that's what you know us as here today. Chairman, I'll kind of wind down my remarks by giving you guys 4 features of co-ops. Number one, we're private, member-owned institutions. We have democratically elected boards of directors. Again, many of the folks that you see here in the room today are democratically elected boards of directors who make all of the business decisions on the co-ops, and they're held accountable by the members of the co-op. I already mentioned they're not for profit, and you have to be a member of the co-op to receive electric service. So quickly, I process things through numbers. A little bit about co-ops through the numbers. I already let you know that we cover about 72% of the land mass in Tennessee, mainly rural, many suburban, as you'll hear about in a second. That's 3 million Tennesseans. 3 million Tennesseans. And kind of 14 members per mile. And if you kind of want to compare that to our urban counterparts at municipalities, they're at about 48 members per mile, or 48 customers per mile. So if you want to break that number down by revenue, electric cooperatives receive about $33,000 per mile of line. That's in total revenue. Our municipal friends are at about $113,000 per mile of line. So you can see the little bit of a discrepancy there, but that's just the nature of kind of what we work with in urban versus rural. One's not better, one's not worse, but it's just the facts. Mr. Chairman, if I may, before I turn it over to these gentlemen, and they'll probably second and third everything that I'm about to tell you. But we've just gotten through obviously a snowstorm and more to come. Many of us come inside. We obviously like the comfort of being in this room, but the employees of our co-ops are outside. Our line workers are outside. They run to the difficult situations through snowstorms, through other catastrophes across the state that we have. So we can't sit before you today without recognizing those folks. I'm going to turn it over to Mr. Jones and Mr. Parton. I'll introduce Mr. Jones and Mr. Parton both. So many of you already know Chris Jones. He's recognized as a business leader across the state, very well respected, and has served on Governor Lee's Nuclear Energy Council and has just completed his term there. And I'll turn it over now to Mike Parton. Mr. Parton is the CEO of Sequatchie Valley Electric Cooperatives. which is a mid-sized electric co-op here in Tennessee. He'll tell you a little bit about the operation, but something even more special about Mr. Parton is he's about to begin his term as national president of the National Rural Electric Cooperative Association, which is a huge honor. Mike, I think maybe the first from Tennessee. So he'll be spending a great deal of his time in DC over the next couple of years and is really an authority on these issues. So, Mr. Chairman, I'll turn it back over to you and allow you to recognize anyone you'd like.
Thank you, Mr. King. And Mr. Jones, we'll recognize you next.
Okay. Chairman Boyd, members of the committee, and Chairman Boyd, it was an honor to serve alongside you as part of the Governor's Nuclear Energy Advisory Council. Middle Tennessee Electric is the largest electric cooperative in Tennessee and serving about 750,000 Tennesseans, which is about a tenth of the state's population. We serve primarily 4 counties: Rutherford, Williamson, Wilson, and Cannon, and we serve parts of 7 other counties. Our service territory includes cities like Murfreesboro, Franklin, Lebanon, Mount Juliet, Smyrna, Brentwood, Fairview, and Laverne. We are the 3rd largest electric utility in Tennessee and in the Tennessee Valley, just behind Nashville Electric and MLGW in Memphis. We are also the 2nd largest of the 900 electric cooperatives in the United States, so 2nd largest in the country. Though we are atypical with regard to electric cooperatives in size, we prize the virtues of the electric cooperative model that Ryan just spoke about, and we work hard to maintain and enhance those local community connections so characteristic of rural electric cooperatives. Our economies of scale, though, allow us to do some unique and innovative things, like developing the largest solar generation facility in the Tennessee Valley that's owned by a local power company, and experimenting with battery storage, being on the leading edge of technology. But all this is done with our members in mind. Our chief strategic objective, very simply, is to drive to world-class levels of member satisfaction. And we do well in that and are getting better, and we will continue to strive to get better in that. I would certainly be remiss if I did not say that our partnership with the state of Tennessee and with the state legislature is fundamentally important to us. We continue, through our fiber broadband company, United Communications, to bridge the digital divide throughout much of Middle Tennessee by extending our high-speed internet services to formerly unserved or underserved members. We would not have been able to do that and to say that without the help of the General Assembly. We want to be and continue to be a partner to you as we seek to be agents of good for innovation, technology, economic development, safety and security and comfort, and of course to keep the lights on, even when the weather is at its worst. I like to charge our team members, especially our new team members, that they work for the most important institution in their communities. Now, a number of institutions can make that claim, but modern life grinds to a halt without electricity. And I want our team to embrace that weight of responsibility. And I want them to understand that the humility that comes with that and with the virtue of serving. We are at our best when we understand we are servants and when we have true gratitude for the opportunity to serve. I'm certainly thankful for that, and I appreciate the opportunity to be here today, Mr. Chairman.
Thank you, Mr. Jones. Mr. Parton, you recognized.
Thank you, Mr. Chairman. Very well said, Chris. Thank you for those comments. I'd like to also make the note that I'm a proud constituent of Russ Bricken. I live in the Monteagle area, farm boy there, and certainly enjoy working with him as he works throughout our communities. I'm the president and CEO of Sequatchie Valley Electric Cooperative. We're headquartered there in South Pittsburgh, Tennessee, serve 5 southeastern counties all the way from the Alabama state line up towards and serve into Fall Creek Falls, into that area up towards Cumberland County. We serve 40,000 meters there in those rural counties in southeast Tennessee. Very proud of the fact that we also have diversified, that we're in the propane business, have several thousand propane customers, and also thanks to you all, we're able to be into the broadband business. It's been very successful, very well received by our members in the service territory that we live in. One of the things that Ryan talked about is our governance and how that works. We have 11 board of directors that are elected across our service territory. Serve terms, they're divided out just like each of you are across the districts, and represent those well. We meet monthly, discuss various issues and policy issues on a monthly basis. The territory that we cover is very rural. We have 3,000 miles of line, or plus 3,000 plus miles of line. And you think about that, that's as far as from here to Juneau, Alaska. And that's a lot of right of way that rural territories, rural utilities have to take care of. Treacherous territory, we talked about our linemen and the work that they do. Certainly is very underappreciated many times when those folks are out there in all hours of the night and day. We're a TVA distributor, as you all know. We, like Chris, we have a solar project that TVA allows us to be able to do 5% of our load with alternate sources of energy. And we've chosen to do that with solar. Ryan mentioned to you that I've got the honor of representing the nation's electric co-ops in Washington, D.C. as their national president. Start that project in the month of March at our national convention. The National Rural Electric Co-op Association, we serve 900 electric co-ops all across the country. We're in 48 states. 800 of those are like Chris and I that are distribution co-ops. Then 100 of our members are G&Ts, kind of like TVA, scattered across the country. And we represent 60% of the land mass of the United States. So it's a large footprint that America's electric cooperatives cover. There's a lot of issues that we have to address. As our headquarters in Washington, D.C., you can imagine that a big part of our focus is on government relations, issues that our cooperatives are facing all around the country. If you look at our cooperatives in the West, one of the big issues that they face is wildfires. You can't go to a meeting or to a co-op in that part of the country where that's not an issue that they're talking about. You go to my colleagues in the Northwest, we're trying to work on stopping the breaching of the lower Snake River dams. A lot of those co-ops out there get their power from the hydro dams, and so it's a big issue. But all around the country, the issue that we have all rallied around is reliability. We can't take that for granted at all. We've prided ourselves in a 90-year history in that we talk about the safe, affordable, reliable, responsible power. We've really focused on the responsible part over the last few years. And I think we may have taken our eye off just a little bit on the reliability part. And so I appreciate the efforts of the state of Tennessee as they work towards a modern day solution to our reliability problems. We have to have power that's always available. One of the key mantras that we have on a national level is that energy security is national security. For many, many years, we were at a no growth to a declining load growth in all of our utilities around the country. That's no longer the issue. Data centers are the topic of the day. I'm on our national bank board there near Dulles Airport, there in Northern Virginia. And you have data centers just popping up all over the place. Sequatchie Valley Electric Cooperative, our peak load that we met a few weeks ago was about 250 megawatts. In one of those buildings, data centers, the load is almost twice as what my whole system is in 5 counties in Southeast Tennessee. So data centers are a real threat to us. And so we have to come up with solutions. And that's one of the things that America's electric cooperatives are working on to be a solutions provider. How do we go from where we are today to be able to meet the needs for the energy consumption that continues to grow each and every day? So, Mr. Chairman, thank you very much for the opportunity.
Thank you, Mr. Parton. And to both you and Mr. Jones, I very much appreciate the work that you guys do, and especially with the snowstorm going on today. It's just a reminder that that you guys, the linemen, are out there all the time, you know, making sure that the lights are on and the heat is on, and it's a huge task, and we appreciate all the work that you do. Members, while we're out of session, does anybody have a question? Representative Bricken, you're recognized.
Thank you, Mr. Chairman, and the panel. Thank you for all you do, and Mike, in particular, I'm glad to represent you. A question: I've been concerned with TVA's whatever you call it, efforts or not efforts, about removing capacity over the last several years, especially taking coal power plants offline. And, you know, we've been subjected to some almost brownout situations. I guess I want to kind of hear, with the new administration in Washington, do you think we're going to get some better guidance to TVA to be certain we don't get in that situation down the road?
Anybody that wants to take that one, you are.
Sorry, you want me to?
Chris, you're recognized.
So, Representative, these concerns are, you know, Mike spoke to that to some extent, but these are concerns that are consuming much of our time as we work with TVA and advocate for greater capacity. Certainly, we need that. With regard to coal, TVA is actually, if I can put it this way, in an advantageous position in terms of decision-making relative to coal. Their coal plants are aging to the point to where it's going to be difficult to refurbish them to the point to where they'll be productive and affordable. They are pivoting toward necessarily more natural gas production in the short term, and more natural gas generation. We need that as a bridge fuel until we get to greater nuclear capacity. That's the answer for the future, I believe. That's base load. That's always on. That's carbon free. We need everything we can to be brought to the table, renewables as well. But I think the big piece right now is to help encourage TVA to continue down the path they are. They need to get more aggressive, but we need to be supportive as well. And there are a number of issues on the table here, Representative, that complicate this matter, including TVA's debt capacity right now that is congressionally mandated. They have a debt cap. And so capital is what they need, and they are up against that debt cap. So this is an enormous issue. And again, Mike in his leadership role within NRECA is going to be able to help facilitate that. The state association, all the co-ops, all the munis in Tennessee, we are certainly pushing TVA to make sure that we've had adequate capacity. And we don't for the short term, so we need to be working hard. Mike, or Chairman, I'm sorry.
Yeah, Mr. Parton, you recognize.
Thank you, Mr. Chairman, and thank you for the question, Representative Bricken. It's an issue all across the country. It's not just a TVA issue. As the nation transitions away from coal to other technologies, natural gas is the only solution where we can have that always on, always available capacity. And that's not a short-term solution in itself. If we ordered a gas turbine today, it'd probably be 5 years before we could bring that online. So as America's Electric Cooperatives, we are very pro all the above approach and whatever it takes to keep the lights on, because we certainly feel that we're behind the 8 ball. And as we try to meet this ever-growing need here across the country. So great question. I think Chris is exactly right, though, in that we have to look towards a nuclear option. That has to be the long-term solution in this country. It's happening all around the world. And one of the things that as the nation's co-op association is doing is working on permit reform. It shouldn't take 20 years to permit a nuclear plant in this country when we've been doing it for a long, long time. Thank you for the question. Thank you, Mr. Chairman.
And I wanted to let everyone know, anyone in the audience or members of the committee, and they were going to be here today, but in 2 weeks, we're going to have Wes Hines, who serves on the Nuclear Advisory Council with me and Chris Jones with the University of Tennessee. He's going to be coming and doing a presentation on new nuclear basically the small modular reactors are just the future of nuclear energy. And if you don't know, we're on the cusp of a nuclear renaissance. And I think Tennessee's leading on that. Members, we are pretty much out of time. So I just once again want to thank Ryan and Chris and Mike for coming and talking with us today, and especially coming on this snowy day. I wasn't sure if y'all could make it, so I'm thrilled that you're here today. And sorry you had to sit through such a long committee. But members, we are going back into session, and that completes our business for the day. So this meeting is adjourned.